second question on this issue is the element of pro bono. Lawyers do a lot of pro bono work. Doctors Without Borders, they do a lot of pro bono work. Dentists do pro bono work. Some gentleman talked about wisdom teeth or root canal or something. There's a firm in town here of dentists, dental surgeons, that once a month they devote pro bono their services to the needy in this community that need dental health. What's to prevent therapists from doing this type of work that they feel is necessary, or a demand for, or a request for, pro bono? If they do it pro bono, this resolution has no teeth. I don't believe a pastor is going to charge one of his parishioners. If the parishioner comes and asks for help on this issue, he's not charging, it's pro bono. So there's nothing to prevent whatever this nefarious issue of therapy is from being done without a fee. And third and finally, Madam Chairman, my concern on this is I've counted in this resolution 9 times references to minors, or as we know, the children. And it also is highlighted in chapter 9.90, .010, Declaration of Policy, and I quote, "The purpose of this chapter is to protect the health, safety, and well-being of minors," the children. If there is such abuse, and I have yet to see any evidence in Pima County where this is a rampant problem, where there's all this abuse of therapy and therapists, but be that as it may, if there is such abuse that's being alleged by so many people about this therapy, there is an agency called Child Protective Services with laws on the books that exist already. Call Child Protective Services. They're the expert in these areas. Let them investigate this. And if there is indeed child abuse, let them take the sanctions that they are authorized to do it. We already have issues that allow for protecting children. If these therapy sessions or therapy practices do in fact result in child abuse, call Child Protective Services and let them investigate it and make the determination, as they are the qualified ones to make such determination. I think it's irresponsible for this board to be making ordinances of any nature without deep contemplation of the unintended circumstances, and just to make a ordinance or a law for the sake of making an ordinance of law is irresponsible leadership on our part. And I urge that this ordinance be voted down. Thank you, Madam Chair.
Thank you. Supervisor Pima.
I just wanted to respond rather quickly, because I don't think this is irresponsible at all. And Supervisor Christie, has said repeatedly that he doesn't think these things that we do matter in county business. Excuse me, we do have a responsibility to protect the public health, which is codified in the Arizona Constitution. And that's exactly what this affects. Rampant abuse is what we should address. I would think that we would want to protect all our children. Even if it happens once, it's probably something that's wrong. And if one person takes their lives because of how they felt from all of this, shame on us.
Supervisor Miller.
Madam Chair, I too would like to thank everyone for coming to speak. As many have spoken before, this is extremely complex. I heard a lot of, I just want to be accepted, accept me for who I am, what I am. It works both ways, folks. And this is the problem that I see with this ordinance. It's very one-sided. There's no law in the books mandating conversion therapy. And if someone put forth an ordinance to do that, I would vote totally against that. That is wrong, telling people what to do. So remember, it can work both ways, and be careful. This is an incredibly slippery slope that we're going down. I have many gay friends. I grew up with a young man who went through, he was gay, and he also went through a period of time where he got married to a woman. And then later on decided that he was gay. And he got divorced, and he lives his life as a gay man. And he went through a lot of therapy. And now if you see this, what's happening, he had questions when he was getting married about his sexuality. He was able to get that counseling. This ordinance would not allow him to get that counseling, and it's very one-sided. My concerns center around the rights of parents, which are defined in the Arizona Revised Statutes, Title 1-601, Title 1-602, as well as the rights of patients and counselors, medical doctors and therapists, or anyone else who might be in the business of charging a fee for services related to an individual seeking this type of information or counseling. I don't have children, but I wouldn't want anybody, and I don't want anybody telling me how to raise my children, nor do I think it is the role of the supervisors to wade into this arena. Quite frankly, it scares me to death. And it should scare everyone in this room for the reasons I talked about before, because if you get a board majority that goes against your beliefs and votes for something like this, you're not going to be real happy in it. And once you get on this road, you're setting a precedent. So be careful what you wish for. It is a loss of freedom and liberty. And while this particular ordinance may be something you agree with, I'm just putting it out there. Remember, the next one might not be. And on page 2 of this ordinance, under the definitions in item C, it states sexual orientation change efforts means any practice in which a person seeks to change another person's sexual orientation or identity. Any practice. Going for counseling. Some people are talking about the extremes. I think I agree. I haven't heard of electroshock therapy being used in years, and I don't think it is. And if anybody has evidence of that, I think as Supervisor Christie stated, report it. We have Child Protective Services, report it. It's incumbent upon all of us if something like that is going on. So a conversation with a counselor, having a conversation and showing alternatives that may advocate for being heterosexual would be construed as seeking to change that person's sexual orientation or identity. It would certainly curtail and restrict communication from a therapist or a counselor regarding all of the alternatives. With that threat of a fine, of being reported, this stifles your First Amendment right to free speech. We've all received a letter from the Center for Arizona Policy, prepared by their attorneys, which provides very compelling First Amendment arguments related to the violations of free speech. In addition, I believe that passing this ordinance will put Pima County taxpayers at risk for loss of federal funding, and someone mentioned state funding earlier, and we've received that information in letters from an individual at the state legislature, due to what I believe would be a violation of the constitutional rights of the taxpayers of Pima County. I believe we will absolutely be challenged on this in a court of law. This puts taxpayers at great exposures for lawsuits, which could result in loss of funding from the federal government and the state, as well as the legal expenses to defend this. And in the event we lose, I believe there is a strong possibility we would probably have to pay attorney's fees as well as our own attorneys, and it is going down a dangerous path. And the one thing that I think we've all heard all day, we want to be loved, we want to be accepted for who we are. But what I'm hearing from a lot of people, and what this ordinance is telling me, We're only accepting and loving and accepting who we are if you're on one side. We all need to be loved and accepted. And this ordinance, I believe, is going to cause a lot of problems. And I also believe that it's a dangerous path to go down in terms of constitutional rights. And as a result of that, I am going to vote no on this ordinance.
Supervisor Valdez.
Madam Chair, I think we've got a lot of discussion in terms of the legal ramifications of some of these issues and as well as what it says legally. So I'd like to address a set of questions to our council who's familiar with the ordinance. Madam Chair, Madam Council, does this prohibit a pastor from offering advice on sexual orientation to a minor?
Madam Chair, Supervisor Valdez, this does not restrict the speech of a religious leader with their constituents. The operative language of the ordinance is very narrow and very short. It says no person may engage in sexual orientation change efforts with a minor in exchange for a fee. So it prohibits this type of therapy given in exchange for a fee.
Madam Chair, Madam Council, so it does not prohibit a general discussion if a young person has some questions about their sexuality or orientation, other than with a licensed therapist who is being paid for such services.
Chair Bronson, Supervisor Valdez, I believe that the way the ordinance is worded, there could be a general discussion with a licensed therapist. What the licensed therapist could not then do in exchange for a fee would be engage in the actual therapy that has the intent of changing orientation or identity of that minor.
Does this impede on First Amendment rights?
Chair Bronson, Supervisor Valdez, our Chief Civil Deputy, Andy Flagg, worked with staff on the language of the ordinance, and he analyzed the various potential legal challenges to it. He provided that advice to the individual board members in the form of an attorney-client privilege memorandum, and he went through some of those issues. If the board wishes to discuss those today, I would recommend that the board vote to go into executive session, and we can discuss those further.
I think the answer to your question is no. I think you didn't understand.
Let me ask. There's been an allegation that this ordinance and the way that it's crafted allegedly violates First Amendment rights. Do you believe, at least on the surface, that it does?
There are certainly potential legal challenges to the ordinance. As Mr. Flagg has advised, our office has concluded that it is indeed defensible, and we would be prepared to defend it legally.
Thank you.
Madam Chair,
Supervisor.
could we, the board members, take a vote to release that letter so that the public could see what was contained in that letter? I'd like to make a motion to release that letter from attorney-client privilege.
Can I second that?
Yes.
Roll call.
Supervisor Christie?
Before I vote this, we are voting to release the letter.
Yes.
I vote yes.
Supervisor Diaz? Supervisor Miller?
Yes.
Supervisor Valdez?
Aye.
Chair Bronson?
Aye.
Motion carries back to the motion on the floor, the discussion.
Madam Chair, could we, I think, elaborate on Supervisor Valadez had some questions about what the county attorney Flagg.
I think that at this point, we are back on the ordinance.
That was.
We are back on the ordinance. We need to finish the motion on the ordinance.
But Madam Chair, that was the point of releasing the letter, so that we
It
could
is.
discuss the content of
No,
the
it's
letter.
not appropriate here. It's not on the, it's not, excuse me, the order,
Madam Chair,
there is,
point of order, that's the point of having that
No.
question asked.
I may have been your point, we voted to release it, we did not vote to discuss it.
That's what we're here for, to discuss the alternatives.
I'm
and to
sorry, there is
discuss-
a motion on the floor that we have to
That's right, and
complete.
that we're having a discussion and questions and answers, and Supervisor Valadez asked a question that couldn't be answered without the release of the letter. I don't see what the problem is. We should have open and fair debate here.
Madam Chair, if I may suggest,
Yes.
why don't we ask the attorney to just address the issue now that we've released that information on the First Amendment question that I asked?
All right, Chair Bronson, Supervisor Valadez. I'm flipping through my material because I'm looking at that memorandum that was prepared by Andrew Flagg in our office. His conclusion was that although someone could certainly allege that their First Amendment rights were being violated by this, that would not be a meritorious legal claim.
Thank you. All right, we have a motion on the floor. We were discussing any further discussion on the item, and that is to approve the ordinance as amended. I do have one comment. I think that this is something that is within our purview as public officials. I think we have an obligation to protect the public health of those least able to do so. And I am reminded, I think at this point, given our discussion, of a statement by Martin Niemöller regarding the Holocaust. And that is, first they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. And then they came for me, and there was no one left to speak for me. I think we need to speak for the children in this community. And with that, roll call.
Supervisor Christie?
No?
Supervisor Elias?
Aye.
Supervisor Miller?
No,
Supervisor Valadez?
Aye.
Chair Bronson?
Aye, motion carries.